Okay, we'll go ahead and call the meeting to order. Could I get a roll call, please?
Commissioner Laird? Commissioner Laird?
Oh, present, sorry.
Commissioner North?
Here.
Commissioner Milne?
Here.
Commissioner Nicolason?
Here.
Chairman Frew?
Here. Could I have everybody join us in the Pledge of Allegiance?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Okay, we'll move on to the approval of the consent agenda.
Mr. Chairman, I move that we can approve the consent agenda.
Second.
Moved by Commissioner North, second by Commissioner Nicolason. Any discussion? All in favor?
Aye.
Any opposed? Motion passes. Move on to contracts, agreements, and resolutions. Resolution 18-23 approving the transfer of Wyoming Horse Racing LLC operations from premises located at 330 West F Street, Casper, Wyoming 82601 to the premises location at 3243 Talon Drive, Casper, Wyoming 82604.
Mr. Chairman, I would make a motion to allow public comment if there is any on this particular resolution.
Motion's been made by Commissioner Nicolason to allow public comment. Is there a second?
Second.
Second by Commissioner Laird. Any discussion? All in favor?
Aye.
Any opposed? Okay, we'll open this one up for public comment. Is there anybody that would like to make a comment on this transfer? For or against? Okay, with no one to make any comment on this, we'll go back to, do I have a motion to approve?
Mr. Chairman, I'd make a motion to approve Resolution 18-23.
Second.
Motion made by Commissioner Nicolason, second by Commissioner Laird. Any discussion?
Mr. Chairman, I appreciate the applicant's willingness to have discussion with us, and I think that this is a location that's going to work for the intended purposes, and I'm in favor of it.
Okay, any other discussion?
Mr. Chairman,
Commissioner Milne.
I'm glad to see this come forward, and that the public did have a chance to comment. But I'm glad to see also that it moved forward, and we're in a good spot, and I believe you'll be successful up there. And so, good luck with it.
Any other discussion? With no further discussion, all in favor?
Aye.
Any opposed? Motion passes. Thank you. I now declare the public hearing open for the consideration of VC 23-2, variance to reduce setback requirements between residential use and light industrial use in a light industrial zoning district. The hearing will be conducted in accordance with state statutes, the rules of the Natrona County Commission, and other applicable laws. We have a report from staff.
Start slideshow. Thank you. So this is a variance to reduce the setback between a residential use and a light industrial use in a light industrial zoning district. The address is 2070 Doane Lane. It is Doane Lane, Lot 3, commercial. This property is approximately 6.5 0.6 miles south of I-25 and Howard Lane intersection on the Salt Creek Highway on Doan Lane. This lot is the third lot east of Salt Creek Highway on the north side of the road. The zoning for this lot is light industrial. In light industrial, the minimum acreage, the lot size is 2 acres. The adjacent land uses are light industrial to the north and south. To the east, it's urban mixed residential. And to the west, it is light industrial. Water source is Wardwell Water. On June 13th, 2023, the Planning Commission recommended denial of case VC 23-2. Those speaking in favor were Patrick Lewan and Paul Herbert. Those speaking in opposition were none. So this is your subject property right here. The subject parcel was purchased by the applicant on February 20th of 2023. They're now seeking a setback variance that would allow them to retain the existing Kwanzaa hut structure and also allow for a larger area to facilitate the construction of an additional structure on the lot. Currently, there is a manufactured home located on the subject site, but the applicant plans to remove that. The 2022 zoning resolution requires a 100-foot setback when a light industrial parcel is adjacent to a residential district. This parcel is 0.5 acres, when the minimum acreage is 2 acres for light industrial, so it's considered a pre-existing non-conforming lot. However, the 2022 zoning resolution stipulates that new development on non-conforming lots shall comply with all bulk and use regulations for the parcel's zoning district. A definition of a non-conforming lot is a platted lot or lot of record, which on the effective date of this resolution or as a result of subsequent amendments does not comply with the minimum lot size, frontage, width, or depth required by this resolution. When the countywide zoning was done in 1980, this area was left out due to a discrepancy in the legal description, so it was left unzoned. Then in 1984, the county took action to remedy that error. The county held neighborhood meetings and worked with residents to zone the Doan Lane subdivision. At that time, lots 1 and 3, or 1 through 3, were zoned controlled industrial, and the rest of the area was zoned urban mixed. This was passed with Resolution 38-2-84. In 2000, the zoning district name was changed from controlled industrial to light industrial, but the uses remained similar. The subject property is Lot 3, Doan Lane subdivision, and has been zoned industrial from 1984. Additionally, the 100-foot setback did exist in the 2000 zoning resolution, so the new zoning resolution did not increase this requirement. The key issue in front of us tonight is should Natrona County approve setback variances in the light industrial zoning district which are not grounded in requisite hardship criteria or other applicable law. A variance is a grant of relief to a person from the requirement of this resolution when specific enforcement would result in unnecessary hardship. A variance therefore permits construction or development in a manner otherwise prohibited by this resolution. There are 7 criteria that are the approval criteria for a variance. The first one is that there are exceptional or unique circumstances and conditions applicable to the property involved, and literal application of this resolution to the applicant's property would result in a hardship that is greater than the protection offered the rest of the community. The definition of exceptional would be forming an exception or rare instance, unusual or extraordinary. Unique is existing as the only one or as the sole example, single, solitary in type or characteristics, having no like or equal, unparalleled or incomparable. This parcel is on a non-conforming half-acre lot. The surrounding lots to the east and to the south are all zoned light industrial and are also 0.5 acre lots. The lots directly across the street and to the south is zoned light industrial and abuts an urban mixed residentially zoned parcel, which would be under the same setback requirements for any new development on that subject parcel. In the area between Forbes Road and Melody Lane, there are a total of 6 light industrial zoned properties adjacent to urban mixed zoned properties. The frontage for the subject parcel is approximately 158 feet. The similar light industrial lots have frontages that measure approximately 250 to 90 feet. The setback requirements for the property would be 100 feet on the west side, 10 feet on the east and north side, and 25 feet off of the road. These setbacks allow for 4,961 square feet of available space for development. Using GIS imagery and measuring tools, the industrial buildings that are to the east of the parcel at 1944 Doan Lane and 1939 measure roughly between 5,000 square feet and 3,200 square feet. Meeting the required setback does not allow the applicant the ability to build similar structures and does not result in an exceptional, meeting this required setback does allow the applicant the ability to build similar structures and does not result in the exceptional or unique circumstances that would create a hardship greater than the protection offered the rest of the community. The applicant's desire to keep the current Quonset hut on the property in addition to building a new structure is the basis for applying for this variance. The applicant has the option of removing the Quonset hut and taking full advantage of the space that's available for development, or they can choose to keep the Quonset hut and adjust the plans for development. The choice to retain or remove the Quonset hut does not constitute an exceptional or unique circumstance that would create hardship greater than the protection offered the community. Considering the information above, it is staff's position that this variance does not meet the exceptional or unique circumstances that would create a hardship greater than the protection offered the community for this parcel. The second criteria is that these conditions have not resulted from any willful modification to the land or building, and they have not. It is not the result of any willful modification. The third criteria is the variance sought is the minimum variance necessary to provide balance between the purpose of the regulation sought to be varied and its impact on the applicant. And staff believes that the variance sought would be the minimum necessary to keep the Quonset hut and build a 4,800 square foot building. The fourth criteria is the variance will not result in a gain in use, service, or income for the applicant to a greater extent than available to other landowners in the vicinity. Granting the variance will allow a gain in use and services and possible income greater than that of the other 6 light industrial lots that are adjacent to urban mixed residential lots. These other 6 light industrial lots will require that same 100-foot setback requirement on the subject parcel for any new development. Number 5 would be granting the variance will not impair the use of adjacent properties or alter the character of the neighborhood. Proposed finding of fact is that by reducing the setback between the light industrial use and the residential use, the variance threatens to impair the use of adjacent residential property. The reduction of the setback will contribute to a conflict between defined incompatible uses residential and light industrial, both now and in the future. The setback is established to reduce the effects of these use conflicts. The protections required between residential uses when adjacent to parcels used for industrial purposes also requires a physical screening buffer to be provided and to provide additional protection. The reduction of the setback reduces the effectiveness of the required screening buffers. However, the variance will not alter the character of the neighborhood. Considering the information above, it's staff's position that this variance would impair the use of the adjacent residential property now and in the future. Sixth criteria is granting the variance is consistent with the general intent and purpose of the county development plan and this resolution. The subject parcel is located in neighborhood 8, Wardwell. The 2016 Natrona County Development Plan for this neighborhood is infill of industrial and commercial uses. The industrial use of this parcel is supported through the 2016 Natrona County Development Plan. The variance request is not consistent with the 2022 zoning resolution and its intent to provide protection between incompatible uses. Additionally, the request does not meet the exceptional or unique circumstances necessary to establish hardship greater than the protection offered the community as required by the 2022 zoning resolution as part of the variance approval process. Criteria 7 is the site is not subject to a series of variances that circumvent the purpose of the section, and this site is not subject to any other additional variances. And that is all I have. I stand for any questions.
Christie, I have a couple questions. So if I'm understanding correctly here, they're wanting to save the Quonset hut that's on that piece of land, and they're asking for a variance so they can build an additional shop and keep that Quonset hut there. But the recommendation is that they can do that, but they have to build it on the site of where the Quonset hut currently is located?
Yes, sir, that is correct.
Okay, so what were the setbacks? 'Cause zoning has not changed in that area, correct?
No, sir.
So what were the setbacks prior to the 2022 resolution?
It was a 100-foot setback from a residential use to a light industrial use.
And light industrial would have allowed for residential living on it also?
In the 2000 zoning resolution, yes.
But in 2022,
In
that changed?
In the 2022, that changed.
So this wouldn't, if that trailer was just put in there today, then that would also be in violation of the new?
Correct.
Mr. Chairman, this is a problem that I have with some of the properties that we have out in the county, is because they are non-conforming. They've been non-conforming for multiple years, and it's really not a change of use. It's not a change in the complexion of the neighborhood. And our regulations have gotten to the point where things that have been there for a long time, that we just turn around and look at them and say, well, you can't do that anymore, and you got to do all this other stuff. What's the setback on residential? It's only 10 feet, isn't it?
The side setback on urban mixed residential, I believe, is 10 feet.
So that's where I have the issues with a lot of this stuff, and the way our current zoning, or the new zoning that was passed is.
So, Mr. Chairman, for the property next door that is a residential use, their setbacks are 25 feet from the road. Side setback is 10 feet, and the rear setback is 10 feet. But in light industrial area, when it abuts a residential use, we have a 100-foot setback from that residential use.
And Christie, what is when you have two light industrials that abut each other, what are the setbacks on those?
it's a light industrial against a light industrial, it's a 10-foot setback on the sides and a 10-foot setback on the rear with the same 25 to the public road.
Mr. Chairman,
Commissioner North.
this is just a classic problem that we've got in so many areas around the county where we have residential things that are zoned, in my opinion, arbitrarily. That we look at it and it just doesn't make any sense. When you have an area that should be 2 acres, and yet these are all non-conforming lots, and they have been for a long, long time. I mean, obviously that's a combination of residential and light industrial. Just because it's zoned as light industrial, you know, I just have a real problem with the way this is set up, the way that we look at things, and the way we come up with these evaluations and how we zone some of the areas throughout the county.
Christine, asking for a variance on this. Are the neighbors contacted? Do we have any input from the neighbors as to whether they're for or against this variance being granted for this shop to be built?
We did. We had 2 letters come in from the neighbor to the east and another support letter from another neighbor.
So were they both in support?
They were.
Did we have any in opposition to?
No, sir.
Commissioner Mill.
So all the proposed new building construction is all going to be within the light industrial, correct? Or is it going to bleed over to, these lots are non-conforming, they're all 0.5, not the 2 acre. It's not a combined lot or anything like that. It's all light industrial lot, right?
Correct, Mr. Chairman. This is a fully light industrial lot next door to an urban mixed residential lot.
Okay, so we're only speaking about 2070, right?
Yes, sir.
Okay. And you said these requirements, setback requirements, have not changed between the old and the current zoning?
Mr. Chairman, no, sir, they have not.
And so, is there anything in our current zoning that gives allowances for non-conforming lots within a particular zone to be able to do what they want?
Mr. Chairman, the zoning resolution specifically states that any of our non-conforming lots still have to abide by the bulk and use regulations, which would be the setbacks.
Okay, thank you.
Would that be the 2022 resolution or the one prior to that?
That would be the 2022 resolution.
Is 2020 was the one prior to that?
2000.
2000, and what did that one say?
That one also required that bulk requirements be met, that the setbacks be met for a non-conforming lot.
Mr. Chairman, I have a question.
Commissioner Laird.
So what I'm trying to get is the neighbors don't mind them getting a setback, right? Or getting the variance. Is that true?
Mr. Chairman, we've received 2 letters in support.
That are in support of them doing it. So what does it hurt then if we grant the variance? Do we have the, first of all, do we have the authority to grant the variance?
Mr. Chairman, yes, you have the authority to grant the variance. The criteria that was adopted in the 2022 zoning resolution have those 6 criteria that have to be met for that approval.
And they're a matter they're a matter of interpretation by the commissioners, aren't they? That's how we interpret them. It's because obviously if you get if there's law that says you can give a variance, then we have to decide if it's reasonable. True?
Mr. Chairman, I'm going to defer to legal on that one.
So, Mr. Chairman, Commissioner Laird, you can grant the variance by the criteria that we have laid out in our zoning resolution, which is the same from the 2001, if you make specific findings that this petition, this application, meet all of those requirements. So we would need you to make specific findings of fact that this property, it's an undue hardship for them to comply with the setbacks, and explain what that undue hardship is, among other things.
What did the people who want the variance say was the reason they wanted to do it?
I'm sure that Mr. Hurlbut, through his attorney, will want to speak to you and present their side.
Are they here?
Yes.
We are.
And we're going to hear them before we vote, aren't we, Mr. Chairman?
Yes, yes.
Thank you, Mark.
Commissioner Milne.
Thank you. Looks like the Planning Commission denied this,
Mr. Chairman, yes, sir, they did.
so this is coming before us on appeal?
This is coming before you as a recommendation of denial. You are the determining board.
Okay. No, that would be it.
Any other questions of staff? Okay, thank you. At this time, I'd ask those individuals who wish to speak in favor of VC 23-2 to please approach the lectern. Good evening. Could you state your name and address, please?
Yes, sir. I'm sorry. My name is Patrick Llewellyn. I'm here on behalf of the applicant, Mr. Hurlbut. I'm from Chapman Falls and Lansing. My office address is 125 West 2nd Street.
Thank you.
And I'm Paul Hurlbut, the one applying for the variant.
Thank you, Commissioners. I had planned to do a PowerPoint with you to show you a few things. If we can maybe pull that up, it will help guide my talk with you tonight. Perfect. Well, thank you, Commissioners. I tried to do this at the Planning and Zoning Commission meeting. However, I couldn't get the PowerPoint to work, so we had to do it on paper. I think this is a little bit more effective. Before I get to this, I want to mention a few things that I think are important for your decision tonight. This does come to you as a recommendation of denial from the Planning and Zoning Commission. However, that was a 3-2 vote. Those two in favor were not Mr. Hurlbut and myself. That was a vote of the commissioners there. And so it was a close call. It was a really close call. We had a lot of discussion. I think it was about an hour and a half, maybe, discussion. And there was a lot of talk about this. In fact, there was recommendation of shelving this and getting direction from yourselves on how to go about this for these special lots, if you will. I looked at the minutes. The minutes don't quite reflect that. But there was a lot of discussion, and I think a term used, about a unique piece of property. Again, that was a 3-2 vote in recommendation of denial. Just to acclimate you where we're at here, this is 27 Doan Lane. It's in red right here. To the right, this is present-day Doan Lane, 2070, okay? We've got the mobile home there on what I'm going to call the west side of the property lot, Quonset hut in the northeast corner. Well, why are we here? Why the heck are we here? Well, it has to do with the setback requirement when you have a light industrial lot next to any residential district, whether that be, well, any residential district, I'll leave it at that. This one happens to be next to a mixed urban residential district. And that zoning requires on the adjacent light industrial lot a 100-foot setback. In this case, it's going to be on that west edge boundary. What does it mean for the applicant as applied to this lot? It means that Mr. Hurlbut, as owner of this lot, has approximately 4,961 square foot that he can develop on this entire lot. Roughly 22% of the entire lot that he can build anything on. It's less than a quarter. And I think that this ties into a lot of the factors that are required and findings to issue a variance in this case. Again, to bring it more to light, we have the present day situation on the lot. We've got the rendering on the left, and I just want to call into question here, or point a few things out. The trailer is approximately 20 foot from that boundary line right now. This is, and I think there's a little discussion on this, this is a non-conforming use. This being zoned light industrial, there is no ability for residential use in light industrial. And what we propose, and another thing I point out on this, zoned light industrial is subject to the 100-foot setback requirement. We obviously don't have that as it sits right now. We have roughly 20 foot from that west boundary. And here's what Mr. Hurlbut would like to do. He would like to construct a storage shop, for all intents and purposes, approximately 65 foot from the west edge. We know that 65 is not 100, hence that is the 34.6 foot variance from that west edge. In doing this, if it were to be granted, would actually bring this not only into a conforming use that is contemplated for light industrial, but in addition, it would bring it closer in what is contemplated by the current resolution. In fact, here's a I almost said video rendering, a picture rendering of the storage shop that is anticipated. One thing that I would point out here, and this is very specific and intentional, are the placement of the doors. What you are looking at here is on the long edge would be the east side of this, facing east. The door on the left side, on the short side, if you will, would be facing south. This is intentional. The south-facing door faces the street. The east-facing door faces obviously the east, which is adjacent lot is light industrial. This is intentional, again, to minimize any interruption or any impairment of use, and I'm going to get to that in a second, with the adjacent residential district that is again to the west. So we have doors facing away from the residential district. There were some questions the last time we were here. Well, what the heck does the applicant intend to do with that storage? What does he want to put in there? Job trailers. Approximately 3 flatbeds, 2 enclosed trailers. And why? Mr. Hurlbut, he lives on the mountain, Circle Drive. And he found that this year they started shutting down Circle Drive. He couldn't even get to his house. When that happens, he intends and would like to put his work equipment on trailers, under lock and key in this storage unit. We know that a variance shall be granted upon the finding of certain things. I have this color differentiation here intentionally. Red is what the staff had recommended as being reasons to deny this variance. Green being approved, that we meet that. I will focus on just the red tonight to save everybody the time, and I'll start with the first one. Finding of exceptional or unique circumstances and conditions applicable to the property involved. Well, I want to orientate you to the community, okay? This is a little bit hard to see here, but bear with me. All of the light gray is zoned light industrial. I don't know if I can point with this, but I tried to situate Doan Lane approximately in the middle of this picture. I think what you can see from this is that this community, if we are looking at it, is primarily and predominantly light industrial. And so, in doing that, let's look at the light industrial units that are close by. And why I'm looking at the light industrial, I think you have to do it this way, commissioners, Because if you start going and looking at, well, we have a bunch of half-acre properties. Well, of course you do. You can see it right here. Again, the blue is 2070, the lot in question, okay? But almost all of the other half-acre lots here are residential districts. Why we're focusing on the light industrial is because that's applicable to the property. That's the type of property that this is zoned. That is why this creates a unique and exceptional circumstances. What I found out is when I zoom this out and figure out what's going on in this area, I find that this property is, from my best guess, one of 2 properties in approximately a half-mile surrounding area that is zoned light industrial, and it's a half-acre. One of 2. That is approximately 4.5% of similarly situated properties. And again, I'm talking about light industrial and/or commercial properties, okay, that contemplate something other than residential use. That in and of itself creates a unique hardship specific to this property. We saw some definitions that were in the staff memo. That wasn't in the staff memo when we did this the first time with the Planning and Zoning Committee. I don't know where those definitions come from, but I think what the record you see here, when you compare it to like properties, like light industrial properties, you see the unique hardship and exceptional circumstances. Given the small size of this property, and again, I'm going to harp on this tonight, but this is a half-acre property. It's approximately 158 foot by 137 foot, 158 foot wide, 137 deep. You throw in that 100-foot setback, which is the width, because in this particular property, our adjacent lot is to the west. We are talking about where you can develop on 58 foot of that property. Again, you throw in the other setbacks, we are at approximately 22% that you can even develop on this. Again, less than a quarter. But I want to take it a step further. Before I do that, I'm sorry, I need to hit the second part of this first element, if you will, or finding that this commission must make, is that it's a hardship that's greater than a protection offered to the community. And I want to talk to you about the protection to the community. We have, when you have development on a light industrial lot that's next to a residential district, we have a mandatory buffer zone. That mandatory buffer zone means that the developer, in this case the landowner, must construct something, be it a fence, trees, there's a lot of different things in the resolution that it could be, but apparently to deal with that difference in zoning between the two. I submit to the commissioners that that protection is already built in place. And in fact, I really want to point out here, what we are asking is for you to allow Mr. Hurlbut to move it back further from the current approximately 20 foot back to the 65 foot, get it more in line with the resolution, more in line with what's required in a light zoning lot. And I think that protection's already built in there. We're asking to move it back and knowing that buffer zone is already there, and it'll bring it a lot closer in line to what is anticipated. I want to move to the fourth factor here, that this will not result in a gain of use for the applicant. This is a big one here. Certainly when you look at it at face value, you say, aha, he just wants to use more of his property. Well, what we have to look at in this factor is greater extent available to other landowners in the vicinity. And again, landowners is intentional here. We must, I believe, look at the light industrial landowners, because that's the landowners that you have to compare the use to. And when you do that, it is, to me, absolutely illustrative as to the unique and exceptional circumstances to this particular lot. Let me show you here. I tried, I'm not much of an artist, but I tried to highlight other landowners in the area that were light industrial. I'm going to start up in the top left. I'll call it orange. That lot's 8 acres. 8 acres. It's almost 350,000 square foot. That's adjacent to a residential district. A 100-foot setback on 8 acres is pretty easy to do. Let's go down to the blue, directly south of that, again to the top left, 3 acres. We've got 130,000 square foot. 100-foot setback, not hard on that particular piece of property. And then you can see just moving down, the 2.6 acres, the 2 acres, 1.48. And I want to show you the 1.48. When there was a comparison on the last presentation by staff that says, oh, he can develop a similar building that are similarly situated in the area. Well, those lots that they showed you, they are not half-acre lots. They were on light industrial lots that were right next to light industrial lots. And when you have a 10-foot setback between light industrial and a bigger lot, of course you can develop more on that lot. It's inherent. But the closest one that I could find was 1 acre. It's in purple. It is directly north. But again, 1 acre is twice the size of the lot that we're talking about here. And so I really do think that this commission needs to look at the gain in use when you compare it to other landowners in the vicinity. Again, the important landowners for this balancing act is the light industrial landowners, because that's the use we're comparing. And I think that this affirmatively shows that the use that we're asking for is actually well less than almost all of the other light industrial lots in the vicinity. This is an important one. They're all important. But I take particular issue on this one in regards to what I saw in the staff memo. Under this factor, the 5th factor here, you can't impair the use of adjacent property or the character of the neighborhood. The finding and proposed finding of fact to this commission, what is it, won't impair the character of the neighborhood, so I won't go into that. But let's focus on the use of adjacent property. The issue I have with what you saw in the staff memo is that this talks about incompatible uses. That's not the standard here. The standard is use of an adjacent property. I don't care what zone you're talking about, but when you put 2 different zones together, lots that are zoned differently, you are going to have inherent incompatible uses, except the use for each particular piece of property is absolutely consistent with the zoning. So I don't think that you can look at this and say, oh, well, the storage shed is not compatible with the residential unit right next to it, when in fact, the use of the storage shed is exactly what's contemplated in a light industrial unit. It's one of many. I don't know the exact number, but it's one of very many that is absolutely contemplated. What is not contemplated is what is on site right now, a trailer home, a residential unit. So I really think that this commission needs to focus on, okay, well, how is this going to impair the use of the the adjacent property? Well, let's look to the left. And the whole reason why we're here, again, because the left property to the west is the mixed urban residential, triggers that 100-foot setback. How is it going to impair the use of that property? Here's what I would submit to this commission. It's not. And why? We are asking for a variance to move a structure further away from that line. Keep in mind that we are going to have that buffer zone in place, the mandatory buffer zone, and we're not encroaching on the line, we're not getting closer or anything like that, we're getting further away. It's intentionally designed where the doors I pointed out that are going to point the opposite direction so that any use of this light industrial lot will not impair the use of the adjacent residential lot. Now, turning to the east, how will this variance, if granted or not granted, impact the use of the adjacent property to the east? Well, it's going to impair it quite a bit. In fact, one of the commissioners had asked, did you get any public comment on this? Well, we absolutely did. One of the persons that commented was to the west. This is Jim Edgeworth. He owns 2 storage buildings directly to the east. And what he said, please, you can read it here, but I'm paraphrasing here. Please do not build closer to the line than you have to. Because of the prevailing winds, the snow, I'm afraid that you're going to put drifts across my property where now I can't use my storage sheds. And so when we talk about impairment of the use, I submit to this commission that if you deny the variance, it's actually going to negatively impact and impair the use to the east. The other photo I have here is the other gentleman that offered comment. This is directly across the street to us, Williston, and he approved it. Both of these actually came from our legwork. I think that the county had sent out 85 notices, and to my knowledge, I don't think they received any back, except we had submitted this with the application. So, the last factor that I'm addressing, that it's got to be consistent with the general intent and purpose of the county development plan in this resolution. I really just want to show you the very language of the 2016 plan. Number 4, upgrade roads, infill commercial and industrial, no new residential. We're in Wardwell, and this entire area is, the intent is to go to industrial commercial use. As far as it being consistent with this resolution, I submit to the commission that it absolutely is. I went through the factors. I believe that we meet each one of them. And when it speaks to these non-conforming lots, what happens when you have a half-acre lot that's not even the minimum size for light industrial? Well, the resolution says you may apply for a variance to get away from these hardships that might come with that. And so it's, I believe, absolutely in line with the intent and purpose of not only the plan, but the resolution. And we would ask you to grant this variance, specifically the 34.6-foot variance, allow Mr. Hurlbut to construct the storage shop. And my last comment on this before I turn it over to the applicant himself or any questions, is that we mentioned this in the application, and I just think it's pertinent here, especially before you guys, or the commission, I'm sorry, is that the Natrona County Road and Bridge had reached out to Mr. Hurlbut, not in regards to this project by any means, but where his house is on the mountain on Circle Drive. And they were looking for him for an easement to in their efforts to repave Circle Drive. And if you were to grant, the reason I bring this up, if you were to grant the easement, I think you can do it with any conditions that you want. And I think that condition would require Mr. Hurlbut to come work with the Natrona County Road and Bridge for that repaving project, in addition to allowing him the variance here. So, thank you, commissioners. And I might turn it over to the applicant if that's all right with you guys.
Sounds good.
So my only thing is trying to get the garage doors, the front of the building, to face Salt Creek. There's no reason to face it towards the residential area. That seems like it would be a hardship on them. Any noise we create, everything would be facing Salt Creek instead of facing the residential area going towards the west. So, and as far as the Quonset hut's concerned, it can come down, because if you look at where the doors are anyways, it's going to come down anyhow, because I want garage doors down on that end. The furthest I can get them away from any residential area or any of the residents that live there, you know, permanently. So the Quonset hut, it can absolutely come down. I would love to keep it though while I'm constructing, because the area, it's just, it would be great to have it, be able to lock stuff up there while we are constructing it. So I have no problem with rendering that to be removed from the property as soon as the certificate of occupancy is given, so.
I have a question.
Commissioner Laird.
Well, you just bought this place recently.
Mm-hmm.
So what were you told about any of these restrictions when you bought the place?
Nothing. So.
Did you just buy it directly from the owner?
The realtor. But my whole intentions were is just tear down the Quonset hut and build it, but the more I started looking at it, where my garage doors are going to face, it's going to push it all the way to the one side, so the whole front of the property is going to be facing the residential area. So by moving it to where I can put the front of the building towards there, and I have room to park trucks and bring trucks in and stuff.
Can I tell them?
Do you know what the,
Assessor portion.
yeah,
Commissioner, if I could too.
Yeah.
Because I think this is important. That's a good question. Hey, you just purchased this, what did you do to figure it out? Well, Mr. Hurlbut did look on the assessor's site. It was assessed as residential. Here's the conundrum. They assessed it based off the use, not the zoning. And I think that that led to quite a bit of the confusion in terms of requirements for this lot
For the setbacks.
and the setbacks applicable in that lot.
so did you get that straightened out with the
Well, like,
assessment?
evidently on their websites, they don't, all they zone, everything is commercial or residential. There's no other, there is no other listing on the assessor's website.
And it's my-
Everything's zoned residential or commercial.
It's my understanding that they assess based off the use, and with the current mobile home on there, it was used as that at the time Mr. Hurlbut purchased it.
Well, I'm trying to figure out, because of the new zoning rules, I'm still trying to understand them myself. And so what I'm trying to figure out is why there would be a rule that would prevent him from doing this in the first place. Have you investigated that?
I can, and I think I could show it to you. I think it's this rule right here. In conjunction with the rules in the resolution that talk about when you have basically any new development on a lot. And it's because it's zoned the light industrial, that's where that 100-foot setback comes in. And if we were to comply with all of the rules right now, it simply wouldn't fit.
It's simply what?
Would not fit in the contemplated envelope. This might be the best drawing I have of that.
Thank you.
Commissioner Milne.
When did you buy the property?
February?
Of this year?
Yes.
So just looking at the GIS here, I'm seeing the zoning and everything in that area. Looks like there's 3 others that are in the same boat as you are as far as placement within the same approximate acreage that are your neighbors, one across the street, and then 2 on Blair Lane. So,
Yeah, with the one letters from the fellows across the street that have the trailer across the street.
right, so if we do this for you, then we're gonna have to do it for everybody, apparently.
I don't know. He's got a trailer there and a building, so.
And I tried to figure out why this lot? Why is this unique? Why is this exceptional? And you're exactly right. The only other light industrial lot that is a half acre is directly across the street. Williston is the owner. He's consented to this.
Right, and then you've got another lot on Blair.
Yeah, the one on Blair, I have it here.
It's a larger lot that's been combined, but it's
Correct.
still divided on there. Then the one right across the street from it is also.
Yeah, the one directly across the street is a half acre. The one on Blair is 1.48.
Right. So, looking at this, you know, like I said, are we going to have to come back 4 times or to other people and adjust things? Because they have smaller lots, the rules don't have to apply?
Well, I can't speak to what other people do in the future. But if I was representing them, I would say absolutely, this is a unique and exceptional circumstances based off the based off the property.
I just found 4, it's not that unique.
I don't think there's 4 that are a half acre. I think
No,
there's-
one is 0.75, one's 0.5, one's 0.5.
I think the difference is adjacent to the
They're all
residential
addressed
district.
adjacent.
I don't have that in front of me, but I spent a lot of time looking at the exact same map, And that is combined with another lot, and it's 1.48, almost 3 times the size of what we're talking about here.
But you get what I'm saying, right?
There is one other lot that's a half acre.
No, you get where, if we make one variance, we just keep going, then what's the purpose?
Well, I understand what you're saying. I can't speak to the future. I know this applicant, I believe, meets all the criteria for variance in this case that's applied to this lot. And I would submit that to the commission.
I mean, it's unfortunate that you weren't able to figure out the zoning prior to purchase. You know, but non-conforming lots, that's the problem with non-conforming lots. They're self-generating problems, basically.
I think there's an opportunity to fix this problem tonight.
Mr. Chairman.
Commissioner Nicholas.
Thanks for being here. So when you bought the property in February of this year, the 2022 resolution was in place. And I think what you were saying, well, who is the real estate broker on the?
Edgeworth.
It was Mr. Edgeworth who submitted this letter in support, the neighbor, basically. Yep. Did you buy it from Edgeworth?
No, I bought it from Wheelers.
Okay.
Willis Wheeler.
Edgeworth was the broker involved.
Yeah.
So, my understanding is that you're planning to take the Quonset down eventually.
Yep.
And you're planning on taking the mobile home or the trailer off the property.
Yes.
So you could comply with the zoning requirements if you just change the doors from the east side of the planned building to the west side, correct?
Yes.
It'd fit on the property, and you could access it, access your building by coming around from the west to the east into the doors would be on the west side of your building. So it's hard for me to understand that as a hardship. I think I recognize one of the issues might also be wind with the doors facing into the wind, but I don't know if that's a concern for you.
Well, it's actually better if they're facing the west, because then the wind has a tendency of blowing the snow out of there, where if they're facing the east, the wind's going to blow the snow around in front of the building.
So the wind...
My whole thing is garage doors facing the residential area from a business standpoint, and having them see everything, all the lights on the building are going to be facing the residential area, all that. If I move it and have the garage doors on the other side, all the light pollution is going to be towards Salt Creek Highway, not towards the residential area, not towards the houses, not to the next door neighbor.
You know, I think this property, because of its size, should be residential, zoned residential. And I think what you were saying is, while it was being assessed residential, it was actually classified, the zoning classification was light industrial at the time you purchased the property. And I think it was probably originally intended as a residential lot, but probably because of the non-conforming use, the property owner probably had an opportunity to select whether it be light industrial or residential, because they're right on that line. So, you know, I guess what I am thinking of is not just the current use, and you as a property owner, you're probably the best neighbor, and you probably run the best, tightest ship operation, but it's the future owners, the future uses, the future neighbors, and one of my concerns is, I think, kind of what Commissioner Milne was alluding to, which is a concern not to have a spot zoning situation. We really have to be thinking ahead on how our zoning resolution is going to apply, not just in your case, but in future cases. And so that's part of the dilemma here. It's not really a question, but just kind of part of a discussion. So
well, and that's kind of where I was at too. So if I retire in 10 years and sell the building, and a welding outfit comes in there and they're grinding 24 hours a day, 7 days a week, fabricating, all the doors and everything are going to be facing that residential. If we build it the way I propose, then the garage doors would be facing Salt Creek.
Mr. Chairman.
Commissioner Milne.
Do you have any plans to put any screening or buffering between your property?
I don't have any plans drawn up, no. There is a fence, and it's already 10 feet inside my property line, so I can move the fence 10 feet further towards the residential area, construct a wood fence or something like that, but it's full of wood vines now, it's full of lilac bushes all along there, which have all been cleaned up, trimmed up and stuff, because nothing's been done on the property in the last 15 years, but pit bulls and drugs out of the house. That's all that's been there.
So all your noise pollution, light pollution, et cetera, that's all intentionally being directed toward the east?
Yes.
What is your plans for that 65?
Just to let the grass grow there. The fence, I'm not putting any gates in over there, I'm not putting any garage doors on the back side of the building or none of that.
And Commissioner, if I could, I meant to mention this earlier. When it gets to that buffer zone, if this commission were to grant the variance, I think that they can place conditions on the buffer, including conferral with neighbors, input, and things like that.
So, and also just for your information, yeah, the zone was changed to light industrial in 2000. So it was intended to be different.
Right. I think the intentions is to have all of that zone light industrial eventually, isn't it?
Not non-conformed, we'd have to put all those lots together at this point. But, thank you.
Mr. Chairman, did you talk to any of the neighbors? Because I think if I was a neighbor and I was facing the way you're saying these garage doors are and the light and all that, I would want you to change it. Did you ask any of the neighbors there about how they felt about that?
I've left letters with all of them. And the only ones I got back was the one from Jim, concerned about the snow drifting across his property, and then the folks across the street.
How tall are those, is that vegetation buffer?
6 foot.
Okay, and it looks like it's pretty dense on the,
Yeah.
okay, so that actually works
Yeah,
as a buffer zone as it is.
What's your plan if this doesn't get granted to you?
Then probably tear down the Quonset hut and build it there and face everything towards the west.
And you can do that, that's all something that'll be approved in your mind?
Yeah, it all falls within the guidelines of what's there.
And how much extra will that cost you to do that? Do you have any idea?
Nothing, other than tearing down the Quonset hut. I'm tearing down the trailer house.
And you
Like I said, the Quonset hut's, it's got so many holes in it anyways.
Are you living in the trailer house?
No, but I have cleaned it all out and cleaned up the property.
Thank you.
Any other question? Okay, thank you.
Thank you.
Is there anyone else who wishes to speak in favor of VC 23-2?
Rosemary Saban, 9460 West Zero Road. I want to speak in favor of this. You guys, I know you're hearing how ridiculous this is, that this guy has to come in and ask for permission to do what he wants with his own property. And what he's asking for is very considerate and not out of line. I think you need to just own the fact that the land use plan is not a quality document. It was pushed through far too fast. It needs to be gone through and looked at and revised. But I'm in favor of granting this man what he wants. Thank you.
Thank you. Anyone else that wishes to speak in favor of?
Mr. Chairman, I just had a question for the prior speaker. Were you aware that the 100-foot setback existed in the 2000 zoning resolution as well?
Are you talking to me?
Yeah, you're the prior speaker.
Yeah,
Okay, thanks.
but here, Peter, if I may. Wasn't the intended purpose of the land use plan to simplify and reduce problems for the people?
You made a comment about the 2022 resolution, and I just wanted to point out and see if you were familiar that the 100-foot setback that we're talking about in this case comes from...
It existed
clear back
before.
to the 2000 zoning resolution, so I want to make sure you're clear on that point.
I heard that point when you guys were discussing it up here.
And
But
you heard the staff report that also made that point?
I heard that.
Okay, good.
But, so the land use plan, it had an intended purpose to reduce and simplify the burden to the people, correct?
So there are a lot of intents and purposes in that document. So it is correct that there are multiple intents and purposes of the document.
So I don't think that it resolved that problem, is what I'm saying. It has not met its goal, okay?
And my understanding is you're not in favor of any zoning in the county, is that correct?
I am not in favor of a one rule order over the whole county. You can't do that. It's not the city. You can't have a blanket coding for all of these situations that are going to arise. And I don't think that that was considered. I think it would have been considered if you guys would have taken more time. That I do think. But I think you guys pushed that through far too fast. Okay? Anything else?
Anyone else who would like to speak in favor of? At this time, I'd ask those individuals who wish to speak in opposition to VC 23-2 to please approach the lectern.
Here comes somebody.
Thank you. Thank you, Commissioners. I apologize, I'm nervous. I am Sharon Hubbard. I live at 2242 Doan Lane. I have for 15-plus years. I semi-own it. The warranty deed is signed to me. I've not had a minute to take it down and register it, but, so I didn't know, honestly, if you would listen to me, since by your records, I'm just a renter, but someone who's lived there for 15 years. But I do have a warranty deed that I need to take into the clerk's office and take care of. So do you, can I speak? Am I good? Okay. All right. So a couple of questions, a couple of things. The purchase that did go through closed on February 28th. I have the multi-list for it. Like I said, I'm a licensed realtor and have been for ever, 25 years probably. Jim Edgeworth was the listing agent. And I think Wheelers were the sellers. Thank you, Jesus, for them selling, because it was a nightmare for all of us for the last 20 years with the meth bus and whatever down there at that house. But actually, Nikki Hurlbutt, Paul's wife, was the realtor who sold it to him. So she did the deal, the commission, whatever, represented herself and her husband. And I respect her. She's been a licensed real estate broker here for 15 years, I'm going to guess. Paul would know. So I'm surprised that she didn't realize the 100-foot setback on that side of the property. As someone who has had a real estate license but a real estate broker, I would think, as representing herself and her husband to buy this property, that she would have been aware of that. I'm kind of surprised at that. So if that's the case and we closed February 28th, the fact that they went ahead and purchased it with a layout with that Quonset hut, not Quonset hut, it was surprising to me to put a good size shop in there. And I've heard from lots of neighbors, and because, you know, work in that business, and I apologize for not getting writing sooner or getting out, but it's a little confusing, I think, talking about Doan Lane, and I don't have a PowerPoint or a plat, but the house that sits directly to the west of this property is what you classify, I think, as the most expensive house on Doan Lane. And I get it, there's $35,000 lots with $5,000 trailers sitting on them, but that Oscar and Laura, I've got it in here, but and I can pull that last name up, that's the most expensive house on Doan Lane. And there's a lot of us on down the road from that. But I consider, and I think you consider, Doan Lane from this point on, from 2070 on, a residential, urban mixed residential area, not as a commercial. We've got MCI shop on the corner, we've got Jim Edgeworth's land next to it, and I'm surprised that he's worried about the snow blowing and drifting him in, because he doesn't use those storage shops, I don't think much, other than now that he sold his big 100-foot motorhome off there. That's all he ever did with that shop, actually. So just know when you're talking about this, it isn't, I don't think, having lived there for 15, 20 years, a primarily industrial site. It is residential. And a lot of people are like, theirs was. They have a mobile home or a house and a shop. That's why it's mixed residential use, is what I've always thought, because lots of people across the street from me have that, down the street have that. So, and I have one other, sorry, I'm a jumper. Mr. Edgeworth in the listing said that the manufactured home was grandfathered in. So the fact that it would be in violation going forward to keep a mobile home, or God help you, put a new mobile home on there, because it is pretty nasty. I guess I'd question that. Someone could put another manufactured home in the shop, according to Mr. Edgeworth. He lives next door. So, I don't even know what else to say. I think personally as a realtor, if I lived in that house that you've said was worth $436,000 and you moved somebody's shop, not a welding shop today, not a drilling shop, when I went through the conditional uses permitted in light industrial, someone could put something that supports drilling rigs in there. So you're going to take that building and you could put it another 35 feet closer to their bedroom windows in their $435,000 house. I don't think you'd want that. I don't think that you have a right to decrease their property value by, Chairman, what do you think, Commissioner? I mean, what do you think as far as, what is that if they put that shop in there, or any shop, and encroach that in, get permission from you to move that in for another 35 feet outside their bedroom window, when someone could operate Willie's welding shop 24 hours a day, the light pollution, I mean, that wouldn't decrease the value of their home? I think you have a responsibility not to do that. That's my feeling. I'm glad that Mr. Edgeworth thinks that won't hurt his value, and it probably won't hurt his value because it's light industrial and it's 2 storage shops. I'm really surprised that the one that your office sold across the street, that he wouldn't have a problem with it, but he'll probably make some changes there too, because that mobile home is whatever. Anything would be an improvement as far as that mobile home goes. But the rest of us on Doan Lane, that go all the way to the end, that have residential, are residential, urban mixed residential, I think have a right to, I don't know, property values, but especially Oscar and Laura that live right next door. So, and I'm surprised that there were no other comments. Apologize that I didn't from neighbors, because I've heard, and people, as you know, people will gripe about everything, but that are really concerned about it. And what the trend will be, as Commissioner Nicolason brought up, that what happens then? What's the slippery slope then when that change happens and you grant that? Then what happens to the guy across the street? Maybe that's his plan is he's going to build a bigger shop closer to the people who have lived there again for 20 years, which I guess doesn't mean anything, that it's just going to continue on when you cross some borders that have been pre-existing with light industrial, that it just makes it easier for the next guy to do it. So I guess that's a question. I don't know.
Mr. Chairman.
Commissioner Nicholas.
Ms. Hubbard, can we take a look at that MLS sheet?
Sure, of course. I also have the printout for the assessment on Oscar Dolores property next door.
Sharon, I'll just make a comment, and it's not, I'm not trying to be a smart aleck or anything, but if, you know, I think there's quite a difference between a shop, a new shop being put in place, and a methamphetamine lab.
Yes.
What
yes.
does a methamphetamine lab do to the neighborhood's values?
Oh, we're thrilled. Thank you for that being gone. Really, we put up with the raids and the DCI and the police and the sheriff. I mean, I don't know how many times over the years, and I know some guy got 5 years or something. We're thrilled about that. And I don't have a problem even with a shop. But I guess my main problem, and that won't devalue my property, it won't devalue anybody's, but there must have been a reason, a wisdom to that 100-foot setback.
Sure.
And probably Oscar, I don't know, I didn't sell him that land, I didn't build his house, wouldn't know him if he was sitting behind me. But when, my house at $435,000, I would be protective. And I guess I thought that your firm had talked to them, and I can't believe that they were in support of it. That's what I had understood, which is all, you know, gossip neighbor stuff, that they had actually visited with Laura and Oscar, and they did not give a blessing to say, heck yeah. There's no letter from them in there supporting that, so.
Yeah, and I actually kind of wish that they were here so we could
Yes,
see one
yeah,
way or another.
yeah.
But my
Yeah.
point, you asked the question,
No.
and my point being is if I lived in Oscar's
Yes.
house, I'd deal with the welding shop all day long before I dealt with the methamphetamine.
Oh, yeah, for sure, yes, for sure. And we're pleased that it's gone. And the neighbors, I mean, we're happy that it's sold. But we don't want to create a bigger problem. And again, I know it's not living on the mountain, it's not living at the foot of the mountain, it's not whatever. But it's somebody put in a house that you think is worth $436,000. I think that has to have some consideration, and I'm sorry that they're not here.
I have a question.
Commissioner Laird.
Didn't you like the idea, though, that he said he was going to move all the doors and lights and garages away from the people living there and move it to the front where all of that wouldn't be seen or shine on them?
Well, I think that's a great design. What I don't know is what'll happen next. What will happen if they decide to go ahead and build a shop on the mountain, or go ahead and they're investors. I mean, I think they invest in another property and do that. I think that's probably a better design. But why can't they do that where it's sitting, where they should be sitting, 100 foot from that edge? The Quonset hut is garbage. I mean, I'm hoping they did a phase 1 environmental before they bought it, because
Well, but they said they were probably going to tear that down.
Well, probably. Are you going to require that they tear it down?
I'm not going to require anything, but
Okay.
I'm trying to understand how come you're here and the people who have the $400,000 house aren't here.
I don't know. Maybe they thought, again, I'm just saying what I was asked, or what I was told is that.
But this doesn't
their firm
affect you
didn't.
directly, right?
I'm down the street. I am down the street in a residential area. And I think someone had mentioned, sometimes, you know, when the dominoes fall, I guess the people who have lived out there for a long time, and maybe I'll be long dead by the time it gets to me, but, you know, whose property is sacred as far as, you know, do you want to live next to it? I don't know. I guess that's the question.
I think I hear what you're saying, but I'm like Chairman Friel. I mean, it sounds to me like he's improved it just by buying it.
Oh, hallelujah, yes, for
So
sure.
I'm kind of lost with some of, you know, people thinking that he wants to take the lights off them and the doors off of them, and they won't get the noise and all of that.
Yeah, no.
It sounded like it's more of a benefit to the neighbors than anything that's been there for 20 years. And I'm surprised at what
We
you're
were
saying.
hoping for a greenhouse. Could be anything. I mean, in the permitted uses, I mean, I pulled that up and looked at it too. It could certainly be a lot of things that, what the worst case scenario, what it could be, to me, was drilling pipe and whatever. I mean, you know, so I live within probably, I don't know, 600 foot or so of Granite Peak. So when they run a second shift or a third shift, and they run all the floodlights I don't go out in my backyard, that's for sure. I don't sleep with bedroom windows open because it's the noise pollution. And I don't know, and you can educate me, please, always. There's no guidance that I've seen in the county statutes about noise pollution in a light industrial area, or light pollution or noise pollution when you're running second and third shifts. Can you do that? I mean, I assume you can. I've just not seen it, but I defer to you, so. Okay.
Any other questions of Sharon? Okay, thank you.
Appreciate it.
Are there any other individuals who wish to speak in opposition to VC 23-2?
Mr. Chairman, before we get to a point to make a motion, could I request to have the applicant return for just a second, another question or two?
Okay.
Yeah, so we talked a little bit about screening or whatnot. Would you be, if we approve the variance, would you be open to that as one of the conditions?
Absolutely. I'll put a greenhouse in if that's what they want. I would love to.
How about a condition that your plan stays the same, that you don't have excessive lighting on the west side or doors? Would you be agreeable to those conditions?
Yep.
Okay, thank you. That's all I had.
Commissioner, can I, as the applicant's attorney, can I just throw my foot in?
No,
just for
no,
a second?
no.
If the commission is considering putting conditions on a variance if granted, I think I don't want to sign Mr. Hurlbut, and I know he doesn't want to either, up for something that is so not economical as when it comes to the buffer. So I just want to caveat that. What's contemplated in the resolution, I think, it would be required anyway. But I just want to throw that out there. Thank you.
So is there some guidelines on buffer areas as far as what's expected in them, or?
Yeah, that's in the resolution.
There's some guides.
Okay.
There's some guides in the zoning, current zoning.
So I just have somebody draw it up and then submit it with?
And just talk to Chrissy.
Okay.
It's easy peasy.
Okay.
Thank you, Commissioner.
Thank you.
Thank you. All right, there being no others to speak for or against VC 23-2, I now declare the public hearing closed. Do I have a motion?
Mr. Chairman, I move that we approve VC 23-2 with all the facts and findings on the condition that it does not change the neighborhood, and he's already got a partial buffer there that's 6 feet tall that's vegetative, which is one of the conditions. He may have to put the rest of it in or change that to a fence if he chooses to do so, but that's my motion.
Motion made by Commissioner North.
Before I say something, Mr. Chairman, is there really a real estate company called Cutthroat Real Estate?
Yep, there is.
I thought something was funny was being handed to me. I second the motion.
Second by Commissioner Laird.
Mr. Chairman.
For approval. Discussion, Commissioner Milne.
I'd make a motion for amendment to include conditions of no west side doors and minimal lighting on the west side to prevent noise and light pollution.
Mr. Chairman, I approve that amendment.
I'll second that amendment.
Okay, now I got three of you on it. All right, so we've had an amendment made to the original for no west side doors or light pollution. And that was seconded by Commissioner North. Any discussion on the amendment?
No, I think it's a good idea. I think that they said they would do that, didn't they? That's what they were going to do. That's why I liked their idea.
Yeah, now it's an actual condition.
Now they're going to, yeah, I'm good with that.
Okay. So any further discussion on the amendment? Everybody okay, all in favor of the amendment?
Aye.
Aye.
Anybody opposed? All right, now back to the original motion. Do I have discussion on it?
Mr. Chairman.
Commissioner Nicholas.
I appreciate the applicant. I think this is a tough call. I think this is one of those times where we're asked to do this balancing in this light industrial because it's a non-conforming size. Part of the balancing here is that there's a greater setback when it's for the site adjacent to the residential areas. I know that we only had one person speak against this tonight, but I do have concerns about future uses, future owners of this particular property and the planned building and the neighbors. I think that we have to look at, the applicant acknowledged there would be incompatible uses between residential and light industrial use, just as a nature, I guess, as just a part of the definition. I think that there will be, or certainly may be, an impairment of the adjacent residential properties, both now and in the future. I think that the increased setback requirement in the zoning resolution mitigates that impairment. I think that the applicant had an opportunity to know what the zoning was and what the restrictions were prior to deciding to close on this property. They did so nonetheless. I think lights and doors aren't the only consideration here. I think there are any number of uses of that building by future users that might also create an impairment or on the use of the properties, adjacent properties to the west. I think that we have to be careful about granting variances. I think it's a serious deal and that we can't just do it because we like the people or because they make a good presentation. I think we really do have to focus on the language of our zoning resolution, which talks about exceptional or unique circumstances and the impairment, both the current and future. So I think in this case, the recommendation of the Planning and Zoning Commission should be upheld, and the variance request VC 23-2 should be denied. Thank you.
Commissioner North.
Mr. Chairman, I think this is a situation that's it's a little different than most that we deal with. For one thing, you've got light industrial directly across the street and right next to it. We also have somebody that's going to improve the lot and make it a better place and clean up something that's been an issue. And because of that, I think that we need to be flexible in what we do, and we need to look at what the situation is. And that's one reason why I support this 100%, is because we need to work with the citizens of the county to make this a better place and make the property values actually more. This is actually going to increase the value of that property by doing that, and not the other way around. I think that's something we need to look at when we're voting on things and we're passing things. And it's going to actually be a benefit to the neighborhood because it is cleaning things up and it's changing. It's going to make the value of that property go up. Yeah, the neighbors to the west, I think you're going to do the right thing from what we've seen with the amendment on there, saying that you're going to put the doors on the east side and not have a bunch of lights and stuff over there where that's a problem, where there's an issue. I think that's something that's good, because you're going to be facing the stuff that's on the industrial side, light industrial side, and not the residential side and what you're doing. So that's part of the reason why I'm supporting this, but I do believe that this is a good use for that property. It was listed as light industrial a long time ago, and it is a non-conforming lot, but we have a lot of those out there, and we need to work with the landowners and the people that have things.
Mr. Chairman.
Commissioner Nicholas, and I'll come back to you.
Mr. Chairman, thanks. In response to Commissioner North, you know, the applicant is planning on improving it anyhow. The applicant is planning on removing the residence and the Quonset and building the shop anyhow, and we heard from him tonight that he's going to make the improvements regardless of our decision tonight, and put the shop, and the only difference will be that the doors will be facing to the west. And I think the discussion is whether that's better for the neighbors to the west or not. And so my feeling is that our job when confronted with a variance request isn't to try and work for economic development. I think it's to look at our regulations and try and make these hard decisions about allowing reasonable use, making exceptions, you know, when they're appropriate, but not pick and choose through what is essentially spot zoning. So anyway, that's my response.
Commissioner Laird.
Thank you. Well, when I heard this, I tried to get a feeling for things, you know, and the whole presentation seemed like it was a big help to the neighborhood that he bought this and that he's cleaning it up and there's no more meth labs there. So I'm asking myself, why would anybody say anything negative about that? And then the issue of the way you move these doors around, I think the neighbors are going to love that. And I do think, I forgot your name, Mr. Attorney.
Patrick Llewellyn.
Yes, I know you. I think you have a beard or something I hadn't seen before. But I agree with you on your analysis of the reasons why we can technically change the zoning. And I liked your assessment on all of the points. And I agreed with you on those. Now, this is another issue where realtors, I guess, sometimes don't understand zoning and they don't explain it well enough. But it does say in the listing that it was light industrial. And so I just don't have a problem with changing this. I think it's a total improvement to that neighborhood, and I think that's what that zoning was intended to do. And now you're caught in this twilight zone of light industrial and another complete zone. And I don't know how we fix that. I guess the statute they could have looked at that one section and accepted it, but they didn't. Sometimes that mass zoning isn't appropriate. And I think that I'm one of the people that think that the rules that were passed do need fine-tuning. And we do need zoning as well. But I'm in favor of letting you do what you want to do, because I think it's going to be good for that whole neighborhood, truthfully. And I think you meet the requirements of the statute based on your lawyer's argument.
Mr. Chairman. Commissioner Milne.
Looking at this, I don't see where you met the requirement of exceptional and unique circumstance, which would create a hardship. And I do see where by allowing you to keep the Quonset hut and then also building the other building, you're receiving you're receiving more consideration than your neighbors. And looking at the property and the sets and everything, and if this was my project, I wouldn't even be asking. I understand why you want to keep the Quonset for potential extra storage or for security measures currently, but in the long run, I don't know if that Quonset hub would be worth it. You'll gain so much more yard space by keeping your original plan and keeping your doors clear than by moving it and having it in this new alternate plan that you have, but that's what you want to do. Plus, we wouldn't even really be here. But that's what you want to do. But I don't see, like I said, I don't see the circumstances. I keep hearing about following the law, following statute, and yet here's a valid code, and we want to just bypass it first chance we get. I will say that that these nonconformists and recognizing that there was potential problems with some of the zoning conflicts with the smaller acreage size versus what the requirements are. And the 2000 code didn't have that. It was actually added so that people could do stuff with their property. So, you know, whatever. But yeah, I can't, I don't see a reason to open this door up for this area. I don't see a reason that we need to give a variance for this particular case when it can be met easily by just going back to the original plan as stated. So I'd also follow the Planning Commission's recommendation of denial.
Well, I see how this one's going to go.
Mr. Chairman, I need a clarification on the law. Can I ask the attorney a question? Do we have to meet all 6 of these, or?
I believe that's, okay. Let's have Christie come up maybe and.
Well, I want your opinion. You're the lawyer.
Well, I will be honest, I haven't looked at variances in particular in a little bit, so my recollection of whether all 7 have to be, they have to meet all 7 or not, I don't recall.
I'm looking at number 5, which says granting the variance will not impair the use of adjacent property or alter the character of the neighborhood. And it's my belief that that was met. So I don't have a statute in front of me so I can read it myself to see what it says about whether we because if we have to meet all of these, every requirement, I would like to know that to save me time in the future.
Mr. Chairman, so the approval criteria says that in granting any variance, the board may attach such reasonable conditions and safeguards as it may deem necessary to implement to purposes of this act and the zoning ordinance. The applicant shall have the burden of demonstrating that the proposal satisfies the applicable review criteria. Variances shall be approved upon finding those 7 criteria. So it does have to meet the 7 criteria.
Could I see what you're reading? Because I don't. Is that a rule or that's not a statute, is it?
This is in the adopted
Okay.
zoning resolution. It's 517D.
Okay, thank you. I'll return this to you in just a second.
Did you have something else to add? Okay.
I'm just going to read this. It'll take me a second.
So, Mr. Chairman, while we're waiting, the motion, as I understand it, is to approve the variance request. I believe Commissioner North indicated adopting some findings of fact. I do think we need to clarify and confirm what those findings of fact are. And my recommendation would be to go through each of the 7 criteria that we now know the applicant has to meet all 7, and then establish the finding that they've met all 7 of them. Does that make sense?
It does. And Dallas has all 7. Unless you have all 7, then we could read them off one at a time.
Well,
And
they're in the staff report. Starting on page 5.
yeah, I got it.
Madam County Attorney, would you take a look at this? I used to be an expert in statutory construction. This is the statute already. But it's a good criteria. It doesn't say. It only says it here. So I don't think one is, and then to read the reason for allowing specific deviation from these regulations. That's the purpose of it, but I don't see where it says that. It does say.
But it doesn't say or, though.
It doesn't say, so what do we do with it?
So.
It does use the word and.
It does at the end, so.
But that's to tie that in to number 7.
My interpretation would be that all 7 would have to be met just because of the use of that there.
All right, so let's run down through this approval criteria. Number 1, there are exceptional or unique circumstances and conditions applicable to the property involved, and literal application of this resolution to the applicant's property will result in hardship that is greater than the protection offered to the community.
Mr. Chairman, I believe that is true because this area is already light industrial. It's already got neighborhoods that are similar, and it's a non-conforming lot. And by removing that trailer and putting in an additional building, he's actually got a unique circumstances where he's actually making the lot a better place, and the neighborhood a better place.
Anyone else?
So, going off staff's report, who did the investigation and research into this, not based off of my beliefs or prior knowledge or anything like that, but maybe going off this report. The choice to retain or remove Quonset at page 7, that does not constitute an exceptional or unique circumstance that would create hardship or any protection offered to the community. That's one of the findings of facts. So I'd go off the report myself.
Mr. Chairman, I don't think that there's anything exceptional or unique about putting doors on one side of the building or the other. And the applicant said that he'll just put the doors on the other side of the building if this isn't approved.
I think we need to remember also with exceptional and unique, it's not that the applicant hasn't said he, or isn't being allowed to put that building in upon itself on the property that he's wanting to do. That was the original plan. He can meet all the requirements stated within our current zoning. All he has to do is put it where the Quonset is.
So the only question that I would bring on that is if you do put that building on the east side with the doors and the lights and everything facing west back towards the residential, and you're leaving that big open lot there, if he leaves tomorrow and decides, I'm gonna sell it to somebody else, and a trucking company comes in there, now you got a truck sitting right next to a fence line, next to a residential area, creating all kinds of noise and everything else that, if I'm living in that house, I'd rather listen to the backside of a building than I would semi-truck sitting out in the lot.
And while that's probably a correct assumption, he could do that anyways right now. We wouldn't even be here.
Mr. Chairman, I disagree with the facts and finding on one. I do think that that this is that it does meet the requirements. I believe that by putting the building where he wants to put it and the way he wants to put it is actually beneficial, and it's going to be beneficial to the neighbors, just like you said. Right now, you could, if he takes that trailer out and everything else, you could put trucks or whatever else in there, and it is light industrial. That is a use that's allowed, and that's going to decrease the value of the neighbor's property as well. So I disagree with that first finding, the staff's finding that it's not exceptional or unique. I think it's extremely unique because of the adjacent properties that are light industrial, that are all non-conforming. None of them are 2 acres. They're all small, and yet they meet that current requirement. So I think it is a unique property, and I think it's a unique circumstances that we need to look at.
Before I move on to the rest of these, I guess, Mr. Llewellyn, did you have a couple of these in which you said were not met?
I'm sorry, that were not met?
Yeah, he did contest, what, 3 of them?
According to staff's report, there was 4 that the proposed finding of fact that was the applicant did not meet. Those were I don't have the color in front of me, but this was all on one slide. It was number 1, number 4, number 5, and number 6.
And I guess I asked that question is if we're reading the zoning regulations now and they say you have to meet all 7, but there's 4 that he does not meet, then myself going through this list is kind of a moot point.
Which ones did you say those were? 1?
According to staff's report, the applicant did not meet criteria number 1, number 4, 5, and 6.
So do you agree with that?
No, I disagree.
Okay, that's the question I was asking.
Oh, sorry.
I thought you were agreeing.
No, I'm sorry.
There were some that you agreed with and some you didn't.
Correct. We did not take any issue with the 3 that they said we met. I believe that finding of fact is correct. It was the 4 that might prevent a variance from being granted that we addressed, and we do believe we meet them.
Do you think you have to meet all 7 of them, the way that's written, and the way you interpret that rule?
I asked myself the same question. I think a district court might have to answer that. I think that the and on 6 and 7 is in conjunction to 6 and 7 to meet those 2. I believe that those 2 are paired, for example.
It seemed like that to me when I read that.
All right, so then I'll move on to number 2. The special circumstances and conditions have not resulted from any willful modification of the land or building.
The Planning Commission said that wasn't a problem, and they said that one was okay, and I agree.
Number Number 3, the variance sought is the minimum variance necessary to provide balance between the purpose of the regulation sought to be varied and its impact on the applicant.
The planning commission also did not have any problem with that, neither do I.
Number 4, the variance will not result in a gain in use, service, or income for the applicant to a greater extent than available to other landowners in the vicinity.
Mr. Chairman, I disagree with that's one of the ones that the commission said that they did not, that he didn't meet. I disagree with that because the adjacent landowners are light industrial. He doesn't have any more advantage than those completely. And the offset, he's actually going to still have a larger offset by removing the trailer than he currently does.
Number 5, granting the variance will not impair the use of adjacent property or alter the character of the neighborhood.
Mr. Chairman, that is the one of the things that I don't think it's going to impair or change the characterization of the neighborhood. You have light industrial to the east of him across the street, and that's not going to change that, and it's not going to affect, if anything, it's going to improve the area by removing some of the other buildings that are there.
Number 6, granting the variance is consistent with the general intent purpose of the county development plan in this resolution. And the site, well, it goes into 7, the site is not subject to a series of variances that circumvent the purpose of this section.
Mr. Chairman, this is already light industrial. He's actually going to be moving stuff that's off the property and cleaning it up and making this a better location. And by doing so, he's actually going to be moving. He's already got a vegetative barrier on the west side, which is one of the requirements. And that is 6 feet tall, which is also part of the requirement for that. He's already agreed to increase that. He's already also agreed to make sure that the lights and the doors are facing east and south to reduce any potential impact to the neighborhood in the area. And because of that, he's working as a good neighbor to increase and work as a light industrial area and not have light pollution and noise pollution moving on to the neighbors.
Wasn't really aware we were talking about him cleaning it up. We were talking about distance. But
he said he was cleaning it up.
Right, but it isn't pertinent. Again, looking back, referring to the finding facts of staff and their professional judgment, it's not unique, it's not exceptional. It's nothing, there's nothing there other than what we're arguing about 40 feet basically for this one particular lot. But the next lot across the street, the two down on Blair, the others throughout the county that may be butting up against each other, such as out toward the airport. That's, we want to go there, that's fine.
Mr. Chairman?
Well, I just want to ask Commissioner Milne the question real quick. You look back to our days at the Sheriff's Department, that neighborhood. Tell me what it used to be and what it is today.
Well, I know.
Okay. It used to be predominantly residential, and it has changed itself into mainly light industrial out in that area, everything. Renana used to be all trailers, and it is all industrial buildings now. So we won't be the first ones to make a change out there is the point that I'm making.
I still kind of like to get the feeling of us doing the right thing. And the only person us not granting this variance to that's going to hurt is the owner. It's not going to hurt anybody else. It's going to help the neighborhood. This is where I'm struggling. I don't think that we passed ordinances or rules that didn't see that we passed rules that help our people. in our community. I can think of one at the city that we had. This lady built a fence a couple feet higher and didn't get permission. And she came in, and the commission then said no, they wouldn't give her a variance. And when she came in, we said, well, why did you do that? And she said, well, she's over by the adult store there. You guys know where that is, right off on I-25. And she said, I just didn't like looking at that when I came out my front door. And we thought that was good enough to give her a variance for 2 more feet, so when her and her kids came out the front door, they didn't have to look at the adult store, whatever they sell in there. And so I think she was shocked that she got that, but it was the right thing to do. And I just don't see, Jim, Commissioner Milne, where this hurts one single soul, except the guy asking for the relief so that he can make it a better property. I don't think that's what our whole ordinance zoning rules were about. And then it's in one of these.
Mr. Chairman, I'd like to call the question.
Okay. So it's been called to question, so no further discussion on this. The motion on the floor right now is to approve this, so all in favor?
Aye.
Aye.
Any opposed? I knew it. Yeah, thanks, guys. Well, it puts me in a situation of having to make a decision here, and I see both sides of it. I see the side that we have 7 points that you have to meet. You have to be able to hit those 7 criteria, and that's not something new. That's something that was in 2000 zoning resolution itself. The flip side of it is that that area has become predominantly light industrial. And facing that building, putting that building where that Quonset hut is now, facing everything towards the residential, I think would be more detrimental than turning the building around and staying 65 feet off of that property line itself. The other thing that I do have somewhat of a problem with is that in the MLS listing that was provided by Ms. Hubbard, twice in this, once on the agent confidential remarks, it says, under the new zoning regulations, and it says the mobile home is grandfathered in, but it says under the new in bold zoning regulations. And then when you go into the property description itself, the property description, it says, please look at the zoning regulations. So twice it was put in MLS, and it was a purchase that was made that had you looked at the zoning regulations at the time, then you would have known that by those regulations, it would have fallen under light industrial and you would have had those setbacks. So with that in mind, as much as it pains me to say it, because I really feel that that building put in there at the right place and off the property line for the amount that it should have been, but the rules are what they are in the zoning, and twice it was noted in here, and I granted, Mr. Hurlbut, you're not the person that is necessarily reading these, and I'm not throwing your realtor under the bus by any means, but it was in there twice, and that's something that you should have known, that it was light industrial and what those rules were. I think going through the 7, we're not hitting all 7 of them tonight, so I'm going to be opposed to moving this forward. So that'll end the portion of the public hearing. And we'll move on to public comments.
Rosemary Swan, 9460 West Zero Road. I want to express the importance of going through this land use plan. It's not right. I think you agree to that, Mr. Chairman. It does not reduce and simplify, and that was its stated purpose, the rhetoric that we all heard. So this is not going to be good when people have to hire attorneys to come in here and put this matter before you guys. You don't need this. And it's not even clearly understood by the people that voted in favor of it and wrote it. I'll leave it at that. Thank you.
Thank you. Anyone else for public comment? Yes, sir.
My name's Ed Mesachek. I live at 1600 Howard, just north of what you've been talking about tonight. Very familiar with that, with the residential and the commercial. So anyway, mine's on a different topic. It's a lot easier topic to deal with than what you dealt with tonight. And I'd like to propose that we get rid of the fireworks ban. I think it's very important that we celebrate our nation's birthday, and we have that. Understand there's reasons it was taken away, but now we need to redo it. So I'd like to simply ask you to reverse that ban.
Could you tell us why you would like to see it?
Well, I've been in the military. I fought for our country. I'd like to celebrate that, but not only for that fact. I have kids. I think it's an enjoyable thing to do on the 4th. I'd like to be able to teach my kids safely and properly how to do that so they can enjoy that. Been caught off guard tonight at your meeting, come ill prepared. Haven't had much time to investigate, come up with reports or anything just yet, but I'm willing to do that, and I'm not going to go away. Been meaning to do this for about 3 or 4 years, and last night was the hatchet that set the wood straight. I'm going to be around. I'm going to be at your meetings. I'm going to bring it up. I'll have reports. I'd like to be proactive about it instead of reactive. So I'd like to see us address the problems that are going to be coming in the future by doing this. So we reverse the ban, we allow fireworks, but let's do it safely. Let's have a place to let them light them off. Let's have some income from it. Let's sell some permits, sell some fireworks, bring in some cash, let the people of the county do what they want to do, and not safely light off fireworks with their family.
So I'm going to add just 2 more comments, and I'm going to let a couple other people talk. But,
okay.
So they're illegal in the county of Natrona.
As far as I understand.
Yeah, I'm telling you they are.
Okay.
So I happen to live on a hillside that I could pretty much see the entire city. And last night, you wouldn't have even known they were illegal. The entire city was lit up with fireworks.
So why are they illegal then? I mean, if there's that many people that are for it, because if you're for it, you would be lighting them off, correct?
So let me add one more to that. So a friend of mine lives out at the trailer court out at Alcova. Same thing was happening out there. Fireworks went off. Their neighbor's bushes caught on fire from a firework that was shot off, and they all ran out there with their hoses to put it out so the entire trailer court didn't go up. So there's a handful of people right there that would be 100% against it, because all it takes is one firework out there, and I'm pretty sure that Mr. Michael Brown sitting in the back there from the Parks Department would not be happy to hear that 155 trailers burnt down because one person couldn't be responsible, like the multiple people that were not responsible last night by not shooting them off because they're illegal.
Correct.
Commissioner Nick Gleason.
Good.
Thank you for your service.
Thank you. Appreciate that.
Thank you for coming here tonight and talking to us about this. It's not an issue we've dealt with in the last year. You know, growing up on a ranch, some of my fondest memories were lighting off fireworks in the corrals in a safe place where they're, you know, we're not tall grass and not really creating a fire hazard. Or shooting them off at Alcova. I mean, I'm not that old, but I'm old enough to remember when we didn't have the ban. So, you know, I think it's an issue for us and me as in the ranching business, having had fires start on other people's lands that then burn thousands of acres of our ranch land, which is, that grass is our livelihood for the cattle and sheep. That it really is a concern, because I think people like you would do it right. You're going to teach your kids what's safe and what's not. You're going to have a fire extinguisher or a garden hose or something like that, just in case. You're not going to do it if it's crazy wind or it's crazy hot, scorching, kind of 110 degree in June weather, right?
Well, I'm glad there's at least 2 of us in the world so far.
But the issue is all the folks that aren't responsible. And
so let's come up with a plan. Let's be proactive instead of reactive on this.
Well,
let's come up with some other things to do, some safe ways to do it, and let's penalize the people that don't have any common sense, that are irresponsible, that aren't doing it right, and let's not penalize the people that really do want to do it right and be responsible.
Well, and I like your willingness. You're not just coming here to say, you know, throw the ban away. You're coming here to say, let's figure this out.
Yes,
so
absolutely. I'm going to be here until next year, 4th of July. And then if it doesn't pass by then, I'm going to come and sit with you every 2 weeks, and we're going to talk about it, and we're going to figure it out. And for another year,
Good.
We're going to deal with it.
Well, I look forward to the discussion. Thanks.
Thank you.
Do you have ideas?
I do. I would like to, I see 3 golf courses, 4 golf courses in the city of Casper, okay? And I don't play golf, but I don't have a problem with golf. So if you want to go play golf, by all means, head out. I'll support you in it, okay? But I don't play it, okay? There's a lot of fields out there. There's a lot of property. We could build something where the people can go. Are you familiar with Glenrock? Glenrock's deal of how they do it? Why can't we do that here? We have a fire department, we have a police department. We need to use them. The taxpayers are paying for it. Why are we not using them? Put them in a parking lot, put some fire trucks out there and let people have at it. We're not just talking about fireworks. When we stood up here at the beginning of the session, we pledged to that flag liberty and justice for all. Not everybody's getting justice here.
I appreciate your enthusiasm behind this. To answer your question, using the police and fire, we used them a lot last night.
I understand that.
That's all they
did.
But
I would like to say, I'm an 11-year veteran of the fire department. And I'm also a 10-year veteran of the military. So I understand both sides of it. That's why I'm coming to you to be proactive, not reactive. I'm coming with solutions that we could do to make this happen. You know, I don't have any report from the hospital from the 80s when it was legal till now when it's illegal, and how many reports there are of injuries and stuff, or what the reports would be afterwards. But we could find out, we could, you know, we'll use every asset we have to move forward in this, to make it legal, to make it safe, and make it feasible for the ones that want to do it, and the ones that don't want to do it, then that's up to them. They don't have to. But don't penalize the people that do want to do it. And that's what we're doing now, is we're penalizing the people that do want to do it.
Well, I appreciate you wanting to be part of the solution, so when you do come back, because I know you already said you're coming back, so.
I'm coming back. If we don't get a yes tonight, we'll get a yes in 2 weeks. If we don't then, I'll be back, and I'll be back, and I'll be back.
Bring your ideas with you.
Okay? I'll draw stuff up.
Be part of the solution.
Absolutely. You have my name, you have my phone number. I'll be back. I'm not going away.
I've got a question for you real quick.
Yes, sir.
Have you attended any of the district fire meetings, board meetings yet?
I just come to the office today and asked them, how do I make this happen? And this was at 4 o'clock.
Okay.
And they said that you guys had a meeting at 5.
Right.
And I didn't even get time to change from work. I apologize for my appearance.
So I'd also suggest you discuss this with the board for the fire district.
Oh, yeah, absolutely. I'd love to work with them on it too, and I imagine I will have to.
Thank you for coming.
Thank you. I appreciate your time.
We appreciate you coming, and I do appreciate your service. The total ban went into place about 2005, right after the Jackson, right about the same time the Jackson Canyon fire went off. That was the reason for the total ban. There was a partial ban before that, but that's when the total ban went into place, is when all the fires up on Casper Mountain, Bessemer Bend, some of the others started. So that's what initiated. Now, this year is a totally different story.
Oh, yeah.
It was like
You
this
could
year-
not start a fire with a blowtorch out there right now.
No, if every year was like this, it wouldn't be a problem.
Yeah, but we all know,
Yeah.
we have common sense, and we know that that's not always going to be the case. So we need to
Not nearly
plan.
as common as it used to be, though.
Right, right. I was told one time, if you had common sense, you were a superhero. So I feel like I'm a superhero, and I feel like you folks are superheroes, because we have common sense, we have a goal in mind, and we're going to work toward that goal.
So, I was born and raised in Wyoming, and I was shot off a lot of firecrackers, especially when my grandpa came and got me, and it was one of the, good memories for me. And what happened is Casper kept getting bigger, and stuff happened, and one time I was somewhere and somebody set a whole field afire, and the fire engines came out. It was out right off where I-25 wasn't there yet, but it was where the old Terrace Drive-In was. And I just asked my grandfather then, I said, how long are they going to let us do this, Grandpa? And he says, not very much longer. Well, so last night, I've got a little dog now, a couple little dogs, and last night they were lighting off fireworks in a park right behind my house. Well, my dog, it hurts his hearing, I guess, and he was running around there whining and crying all night long, and they didn't quit until 1 o'clock in the morning. I turned up my TV with some music on it so I could try to drown it out. We couldn't find him. He somehow got under the bed. He's never done that before. And the only reason I say that is how would you, and this is your job, man. You came here with a good idea, but you got to figure this out. How do you react to a situation where you want to blow up all his fireworks and it's next to some guy's house, and he has a different time element he sleeps during that time? Is he supposed to give that up because somebody wants to shoot fireworks? Now, I like the idea of finding a place to do it, because the city does it up on their property, up on the hill, but if you have all these residents, where can we get to do it? Because one of your major issues is to get the city to allow it, because most of the public lives in the city. Go out to Mr. Nicolauson's ranch, he's probably got a place that if he wanted to shoot off fireworks, it wouldn't be a problem because he wouldn't bother anybody else with them. So I'm just curious, and I don't need to hear about it tonight, I'd like to hear about it the next time you come in, what your plan is, because I respect your service as well, and the service of all of those who serve.
And we appreciate that.
And I think honoring those people are just fine with me. But times have changed. Times have changed, and you can do, we say here, you can do whatever you want on your land, but you just can't interfere with the guy on his. If it interferes with that guy, then you can't do it. It's usually really where the laws are all going now. So somehow you got to figure out how to handle that where you don't have a bunch of people who want to be asleep when you want to shoot off your fireworks. So how that gets done, I don't know for sure.
Well, I already anticipated that question, so I do have a partial answer for you. I think the city has already bought in on the fireworks because they're the ones doing it. They're the ones paying for it. It's held on their property. I'm pretty sure that qualifies as buying into shooting off fireworks. So I also think that that's a conflict of interest when they can tell the U.S. citizen of the county that they can't do it, but they turn around and can do it and charge money to do it. They charge $15 a carload to have people come and watch that fireworks show that they tell me I can't do on my own property. So there's a lot more going on to it than there's just this. However, I want to be proactive. I want to come to you. I think we should use the event center to do it in.
You know where the people out at the lake do it?
Yeah, on that island, last I knew.
Well, they were just doing it, firing them up over the lake. And of course, we had a big fire there last night. I don't know whether fireworks had anything to do with it.
I haven't heard, so I don't know,
But if it did, that's not a good thing. But you're right, the government can do a lot of things the private individual can't do. So if you get that solved, I want to be the first one.
I don't think it'll take a little more than me to solve that one, but I'm going to start with it. But I would like to at least entertain my hand out to each one of you county commissioners to work with you on coming up with a plan to reverse the fireworks ban, find a place to make it safe, address the issues to the problems that are coming so we have solutions for them already, and things in plans and in works and all that stuff. And I just would hope that you would extend your hand out to me to work with me to come to a conclusion where we can reverse the plan and let the public have their fun and do their thing and penalize the people that need to be penalized and not the ones that are doing things the right way, if you know what I mean.
I would add to that or add on to what Commissioner Laird said. I would ask you to go and have a discussion with the city, because that is where a majority of the residents of the county live. And so I would attend one of their meetings and one of their public comment sections and express exactly what you're expressing to us here today.
All right. I was told to come to you first because I live in the county. So I was told to come to you first, but that's where I started, was with the city of Casper. But I'm sure I'll have to battle that too. But with some good thought behind it and some good plans and being proactive instead of reactive, I think everybody can come to an agreement and say it's time to bring it back.
So
I think you'll get some people to talk to you over there. The Marinell and Vice Mayor Pacheco would be two people that would be more than willing to listen to what you have to say.
But you need to be proactive. You need to come up with the plan, and then if we're able to fine tune it or see it, and it's anything we can even do, because we don't have just overall authority to do certain things when it comes to this kind of deal. So you have to come up with the plan in my mind. I want to hear how you think you should solve it, because it's one I've just accepted now over my lifetime. I loved it as a child. I really don't, and I did it with my own sons. But now, I don't think my son does it with his children, to tell you the truth.
And I think it's something that should be able to be done, but I will have a plan on the 18th. That's your next meeting, correct?
Okay, thank you.
I will be there. Thank you so much for your time. I appreciate it.
Thank you. Anyone else here for public comment? All right. Commissioner comments. Commissioner Milne.
All righty. As what was already referred to once, real heavy loss to our community, that especially those that live out there or utilize the lake. Marina did burn down. It's still under investigation as far as I know, but that was a tragic loss of that building. Over 40 years being there, and I remember a lot of time spent there. It's just a shame. I'd remind everybody that the Central Fair and Rodeo is about to kick off next week. Hopefully everybody has time to be able to take off on Tuesday and enjoy the parade that's going to be going through. And I'd like to remind Commissioner Laird that his dog's waiting for him at the office.
He is, and I don't know what he's done by now.
Commissioner Nicolason. Commissioner Laird.
I just wanted to let you gentlemen know that we had a meeting today concerning the jail and the building next door. We have some serious issues of maintenance, and they're having to fix a major piece of equipment up at the jail that has to do with, there's a name for it, but I'm not going to use the name, but it's a big device that chews up sewage so it can get into the pipes properly. Because you can't believe what gets into the sewer system up there. Things that you wouldn't normally see in most sewer systems, such as rubber shoes and nylon stockings and pounds of stuff that I don't even want to repeat. But then it so happened also over in the Hall of Justice, and some pipes, actually I think he said exploded kind of, didn't he? And he explained what was in there. And so I think most of that problem, though, the way he explained it, was the pipes were rusted out and everything, and they had to really do some serious work over there. He thinks he's got it. But then he starts talking a little bit about, was it the stove up there at the jail, and how they put a new one in, and then like in 3 or 4 days, the same stuff's already broken again. And so we do have people that inhabit that building that don't want to be there and don't much care for the law and order and the taxpayers' property. So the issue, really, that's the biggest challenge, is how we deal with that, because it's really getting costly, really costly. I just have an estimate. It's just based upon a weird opinion, but I think it's going to be $5 million to repair some of those buildings, and it's not getting better right now. Just so you know. Thank you.
Commissioner North.
Well, yesterday, 247 years ago, the Declaration of Independence was ratified by our Congress. What a lot of people don't realize is the men that signed that were very influential, very wealthy individuals, and almost every one of them lost their fortune, lost their lives, and because they were willing to dedicate themselves to this country and what needed to come about. We need to remember that in what we do, that we need to dedicate ourselves for the purpose of making this country a better place, and not for ourselves, just like they did. They gave it all up so that we'd have a place to live and we'd have the freedoms that we do today to come here and meet.
And I don't have anything to add tonight.